Okay, this meeting of the Town of Urbana Board of Zoning Appeals is now called to order. First thing on the agenda is the approval of the agenda. And do I have a motion to approve the agenda as it stands?
So moved.
Second.
Okay, all in favor? Aye.
Aye. Sorry.
It's all right.
Raise my hand.
Okay, and now we need to do the pledge of allegiance. Please stand with me. I pledge
Allegiance to
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Things don't roll very well.
No, they don't. Okay, the public hearing regarding zoning amendment 2024-VAR-01-Riddick is now opened. And we will have the staff presentation.
Thank you, Mr. Chairman, members of the board, ladies and gentlemen, good evening. This is a public hearing held on the authority of Section 15.2, 2204, Code of Virginia 1950 as amended. The necessary public notices have been given, and the application materials have been and are available for review in the office. What we have is a quick presentation, kind of review of where we are. We can get the next image up. What is it, the issue are three variance requests. Probably better to understand if you're looking at a plat, but 10 foot for a front yard, a rear yard of 12 where 25 is required, and then for a separate, those two are for an existing dwelling that is desired to be expanded, and the third is for a proposed shed, which is 5 feet into the front yard setback. Next item, please. This was presented to you your last meeting. These are the variance standards, what you can do, to what level you can do it, and basically have to apply the standards to the case in hand. Next item. All right, so to recap, we had a meeting a month ago to consider these requests, and the meeting was continued to tonight because there was a claim, a concern about a vested right with a prior approved site plan. And we'll tear into that in a minute. There wasn't a copy of that site plan available. We've done some research. In some research, the board allowed for the meeting to be continued, so some research could be done. That research has been done. And it is summarized in about a page-and-a-half memo with attachments that was sent out to the board last week. And if we could go to the next one. And this kind of summarizes that page-and-a-half memo. It's in the agenda packet. Okay. So the first item that you have, I've tried to identify these things, is Mr. Riddick, after I sent out, let me step back for a moment. One of the issues that also came up at the last meeting was, why was the variance granted to create the lot in the first place? And that happened in the early 1990s, and the best we could do was provide you a copy of the minutes. And those were provided to the board, those were provided to the applicant. Okay. So that the minutes have to speak to themselves for that. So now we get into the vested rights issue. Okay. Mr. Reddick, after I sent out the minutes from the 1990s, he sent me an email, which is in your packet, item 1A, which had attached to it a site plan, item 1B. If you'll notice to the upper right of where it says site plan, the number 15786-22 Riddick, that is the notation made by the county's building department. That is the building permit number that allowed for the shed to be moved from the adjacent property onto this property and converted. Okay. About the same time, there is item 2, a communication from Mr. Keim, who was the zoning administrator at the time, that says it's approved to go forward. Okay? It doesn't specify a plat, a dated plat. It doesn't say per the attached. It just says, okay, the town's looked at it and approved it. So that's all we have in the record on that. I met with the building official to go over some of this information and came across the item 3, which is a communication. And what I can tell you, what's not in here is the building permit was issued in 21. It couldn't get started because of some HRSD issues, so it was 22 before things really started to move, okay? In August of 22, Mr. Reddick, the applicant, received notice that his building plans were not following what he had submitted, and he needed to revise those plans. Okay. At this point, all I can tell you is I cannot find anything in the record that says that plan or any other plan came back for review here. If you'll remember, in his packet from last month, the blue packet, there was included a original site plan approved 2022, item 4 in my memo. That's item 4. I believe that's what was done to correct the footprint issue, the additional square footage. I can't say for sure because it didn't come back to the town. There's no record of it coming back to the town, but that makes sense that that would have happened in 22.
Can we ask a question, or do we have to wait till you're finished?
You're welcome to go ahead because I know it's a long
When you
presentation.
said notice was given to him that he was not following his drawings or whatever, who gave that notice? The
That was from the
county or the town?
The county, the building official. That's item number 3. That's item number 3 in the packet.
Well, that's when they approved the original site plan, right? Or is that the where?
No,
they-
item number 2, when Mr. Keim, the town's zoning
Right.
administrator, let the county know
Right,
that
right.
he was good to go. Then
Okay.
about 9 months later, there's a communication to
I see.
to
Okay,
Mr.
I
Reddick
got
that
you.
says,
I'm
okay,
sorry.
not quite right there. Okay, all right.
I thought there was additional notice that.
So this is what I'm going to speculate, this one that's entitled, on my memo, item 4, original site plan approved 2022. I think that's an amended site plan that was done to accommodate the building official. There's no record of that coming back. Okay, so now we're into the meat of this. The question would be, does this site plan, item number 4, or the site plan, item 1B, vest for all of this? And the answer is no. You can look at the differences of the footprints and the diagrams and see that there's a lot more here than was ever proposed or amended. Okay, so I think that's a summary of what you've got right there. Now, that last bullet point brings us to a whole nother issue, because there was not an approval of the revision after the building official looked at it. Is there a violation of zoning? There is. But what are we going to do about it? Okay. I'm of the opinion that there's something called an affirmative governmental act. And when the building official gave the certificate of occupancy, that ended it. Okay. With all the mistakes, all the errors, that ended it. Mr. Reddick is entitled, and the Reddicks are entitled to what they have. I said that last month. I'll say it again. I'll say it next month. They're entitled to what they have. The issue before you is, do they get more? Staff's position is, based on the criteria of the variance requirements, they should not. And we have, and with the assistance of the county attorney, who's on speaker on my phone, so if you all know, so for the record, she's covering by phone, the variance, all 3 requests should fall. I'd be happy to take any questions you have at this time.
So nobody has any dimensions of this proposed frame?
We're looking at item 4.
Yep. And there are no dimensions on here either, to
Uh,
know whether the blocks match or not. That shows square footage of this, so we can match it to that? Did you
Okay.
bring it?
There's also a scale on the site plan. There's a scale on this.
There's a scale on the site plan, but because it's been reproduced so many times, I tried to
And I
work
can't
it
do
out.
scales. Sorry.
I tried to work it out, and I'm of the opinion a big block that just says proposed building area does not vest. That's where I'm at. And keeping in mind, there's already been one alteration done on it. I also going to go back to my memo. This is not reflected here. But if you look on the second page,
Second page.
second page of my memo, after the quick, what I tried to do is I believe that's what you asked for, was a summary, a chronology summary of what happened, when it happened. After that summary, I state, second, if the applicant believed there was a right vested in the site plan used to obtain the building permit to such an extent as to allow an addition now proposed, why was the site plan depicting the addition now proposed even submitted to the office? So that's my findings. I'd be happy to take any additional questions. Certainly the applicant's here, and no one has signed up to speak.
Okay. My question is, does the proposed building, and this may have been what you were just talking about, but does the proposed building fit within that block?
I do not know. Mr. Reddick seems to think it does,
You think
but
it
I
does?
would question,
I provided a site plan, should have been distributed to you that shows.
just before the meeting.
Yep.
Okay.
It shows the as-built conditions.
Could we, if you're going to address your question to the applicant, can we have him come up
Oh, sure.
to go on the mic?
Okay.
Thank you. Thank you. So the first page of that site plan is the as-built condition, I'm sorry, that's the, what I'm proposing.
Right.
The one in your left hand, I believe, is the, no, I'm sorry.
I have this one. This is the original.
That's the original. There should be one that's stapled to the front.
This thing,
Yes. That shows the.
which is the same as this thing, kind of.
It's similar, but it shows the amended floor plan based on the change that was made during construction that the building official alerted me to, which I can address.
It would be really helpful for me, because I don't think we have a building official in the town. But if we're talking about David Self, then that just makes it
We
a
can
lot
say
easier.
David Self,
Thank you.
yes.
Okay, so what you're saying, I think, is that this is the proposed, what you're proposing now, and
Yes.
that this is the block that is on
Yes.
this, yes.
It's rough, but it's the, what you showed previously, yes, is the buildable area as I see it. That was approved in 2022 with the site plan. So you can see that, you can see the existing structure on the right, and then the proposed structure on the left, and then the hatched area around that is the buildable footprint based on the setbacks that I was approved for.
Okay. Okay, so I guess I'm going back to Ted. Can I ask you a question?
Yes, sir.
Ted? If you assume that the proposed building fits within that block, then would it not constitute a hardship? And this is the difference between like a hardship and vesting. But, and I guess you could go either way with it, but does that, how come that does not vest?
Yes,
Ted,
yes.
that is a determination that the BZA has to make. You can certainly provide how you see it, but you might also want
Yeah, which I did in my opening statement, there, the three variances that have to be addressed have your findings that you have to make, and those are you. This is what's filled in by the county attorney is how she sees it, how I see it. I think to go to your question though, Mr. Hall, is if you look at these, okay, this shaded area is your building area. Okay. There's a little bit of a outline there that also shows you the building area. Okay? How that fills in that building area is different than how this fills in that building area. There's a variation. I think what Mr. Reddick is saying, oh, well, I did something that covers from that corner to this corner to that corner over here to that I've got it all built out in a block by this, and that's somehow best. I disagree.
And you disagree
Because
it's not
this is your
exactly-
detail. This is your detail. His building permit was for the creation of to convert a shed into a one-bedroom dwelling, a one-bedroom dwelling, okay? This expands that into a separate type of, it's still a dwelling, but it's more bedrooms, it's more square footage. So the original one, the 1B, was this is what I'm going to do. This one in 22 said, okay, I'm just going to do an envelope that captures what I've decided to do in addition to what I got the building permit for.
But I thought the building permit was actually on that.
No, sir. I have to go back to your 1B. The building permit was issued on this.
Okay, I'm getting mixed up between.
I
the
know,
building-
it's hard to follow. It's hard to follow. I
Building
understand.
permit and the site plan.
Well,
They're
yeah,
not one
the
and the
site
same.
plan is the basis from which the building permit was issued.
Okay, so,
So this site plan reflected moving a shed over from the adjacent property and converting it into a one-bedroom dwelling,
right,
okay? There was some additional square footage added on, and to satisfy the building official, this was done. Okay, correct? This
Okay,
was,
this-
no? Okay. That, from what I can tell from this is the next plat in the series that makes any sense.
okay.
Regardless, whether you start with this plat or you start with this plat, those two do not reflect this either in footprint or use, because you're going from a one-bedroom dwelling to a two-bedroom dwelling.
So you, and to get there, you've got to assume that the proposed, it's just, this is a one-bedroom.
Yes, because that was issued about the same time as the notice for the additional square footage by the building official, Mr. Self. That's the only way they match up. None of these plats are dated. None of these plats are stamped by a professional engineer or architect. So it's hard to kind of track these without just tearing through the file and seeing, well, what makes sense? What seems reasonable? And the fact that this one is presented to you, it was presented to you last month by the applicant as the approved site plan from 22, it makes sense that this site plan would have happened on or about the time that he got the notice to amend, because he was building additional square footage. At the end of the day, again, I go back, whether it's this site plan or the original site plan shown on 1B, which was conveyed to me by Mr. Reddick. And I found the exact same site plan in the file with the building official's office, Mr. Self's office, that those two, because of the footprint and because of what they are for, it's for a one-bedroom dwelling. What he's proposing is an additional bedroom dwelling. Those dimensions don't match up.
Does anybody have the actual building permit?
Mr. Self does, but it's,
No, I was looking for the actual building permit. Okay, so what of this proposed have you built already? Anything?
I built that section there that says existing frame residence.
Okay.
Which matches
Right,
the footprint, which is
right,
on 1B.
that matches. Right.
And for the record, I want to state that my name is Chris Riddick.
Okay, you took issue with something that he said. What was that? Can you clarify what that was?
Yes. So to maybe help clear up the issue of the site plans, the site plans that you have before you, I've been working for several years with two previous zoning administrators to get approval for this project, and it was a lot of back and forth, a lot of designs like, oh, you can do this, you can do that, you can't do this, you can't do that. I thought the site plan, item 5, which shows that big block, was the one that was submitted for approval.
That's 4, right?
4.
Yeah.
I'm sorry, item 4. Yes, ma'am. I thought that was the one submitted for the building permit. I wasn't copied on the communication, and I assumed incorrectly that that was the one that was submitted. But when I called David Self, or when I emailed David Self, he sent me the actual approved site plan 1B, which shows
Right.
that footprint. And I recall, I don't have the record of it, but I recall that Roy Kime, Mr. Kime, said, well, we need a footprint. We can't just have a block. So I said, well, okay. I've got my setbacks there, so that establishes the lot. So I'm okay with that. So I submitted, and I can provide copies of that for you. I submitted these plans of the cottage, and I have copies for everybody. And when I started building it, I was like, this bathroom's too small, the utility room is too small, I'm going to expand it a little bit. So I expanded it well within the setbacks that were provided. The building inspector said, hey, you need to amend your permit. So I did. I sent him the drawings, and I think the zoning, Mr. Costin neglected to give you the copy of the attachments that came with that correspondence. But I have a copy of those, and it shows clearly that the original structure does not deviate from, or the as-built structure does not deviate from the proposed structure. I think it's maybe 2 feet. So it's certainly not,
Excuse me, Mr. Riddick, why don't you just give?
Do you have
BCA
another
we
copy?
need to have copies
Yeah,
of
we
that.
need-
yeah, sure.
For the record.
Yep. This is a copy of the attachments that David Self gave me.
All right, so this, what these are is what's there now. Is that correct?
If you'll go a couple pages back, that's the foundation plan. So this is what's there now. It's roughly, the main structure, the
Right.
shed is 10 feet by 26 feet, and then the bump out towards the north is about 8.5 feet.
Okay, but that's what's there now.
Yes.
Okay,
Can you see what you're-
that's what's there now.
Oh,
But
Yes.
you're-
And it
you're
was such a
looking-
small change. I'll note that the cost of the building permit didn't even change. He didn't ask for any additional, square footage change. And those building permits are based on square footage.
Right. So, to be clear, this is what's here now, and you're asking for more to do, for proposed.
Yes, within the setbacks.
within the site plan setbacks.
Yes.
Within the buildable window that's outlined on the drawings, right?
Yes.
Okay. question for Mr. Riddick. Is there any RPA, do you encroach in the RPA in any way?
No, sir. I'm about, in the proposed drawings, I believe, I'm about 4 or 5 feet back.
Okay. So what we have is a lot created by a Board of Zoning Appeals because somebody wanted to build a house and they couldn't because of the way the ordinance was written.
Right.
We now have a lot that is a non-conforming lot because it's not, it doesn't have road frontage, and doesn't meet the requirements of the subdivision or zoning ordinance. We've got a house on that property, which Mr. Riddick, I understand you've renovated, and there's a one-bedroom unit, is that correct?
Yes.
And you had a HARB, Historic Review Board, set of conditions to meet on that?
Yes.
Is that correct? I
Yes.
think we heard at our last meeting that one of those conditions, there didn't seem to be unanimity on the opinion of the color of the paint used.
Yes, I can respond to that.
Okay, and now we've got an expansion of a non-conforming use proposed.
And that's where my confusion is coming in. It's supposed to be expansion, and yet somebody keeps telling us it's still within the footprint, and I just don't see how that's possible.
Can I say something real quick, just to clarify?
Do you want to
Sure.
come up here?
Because I just think that, just maybe my verbiage might be a little clearer. No offense. The building plan that you have,
Which one?
there's the house. The one that's there now,
The one that's there
As-
now?
as built.
Okay.
that was built. When we went to get the approval and, the building permit, it was to build that house.
Right.
It was not to build the condominium complex that we're talking about, that's true, but it wasn't to encompass the entire square footage of
Right.
the entire.
It wasn't a master
buildable
plan.
area. It was not a master plan. We centered that just so on their lot, in the hopes that one day we would build onto within that, all the zoning areas that are legal, all the setbacks that are legal. So the building permit was only for what we were building,
Right.
because I can't tell you how many plans we have gone through to even come up with what we really want to build. I mean, it has changed, it has evolved, and even the little shed that we did has changed and evolved while we were trying to get that. In fact, it was a whole other house until we bought Steve's little shed for $1 and converted it. So I think that's all I want to say is that, just in my head, which is simple, the building permit was for what we built, not for the existing land that fits in the north-south that was approved for that.
I wish we had something in writing that said, this is where you can build.
Footprint, yes.
The actual, and say, you have been given a variance for 10 feet and all the
Can-
things. Do we have such a thing?
Well, I haven't really been able to present what I was going to say tonight, and maybe that could
Sorry.
address it. No, it's okay. I think what we're all getting to is my vested right in this property, and the existence of my vested right in this site plan, which has existed since it was approved. The site plan was approved by a significant and permanent government act, and it shows the orientation of the site and related setbacks and the building footprint. The site plan established the side setbacks to the east and the front setbacks to the north. And the zoning administrator is claiming that the front setbacks is to the east, and that's, his opinion turns it into a non-conforming use after the fact. The site plan has been approved, that's the fact. His opinion is trying to change that. So my my vested right is in the site plan, showing those side setbacks, the orientation of the site north to south. It clearly shows a conforming lot and a proposed structure that I built, and it shows the setbacks in a north-south orientation. The property was initially developed based on those setbacks in good faith, and I've incurred significant expense in the ongoing development of this property. And those are the requirements to qualify for vested right. And to answer the question about why am I even here tonight, why are we all here, I'm doing this because this is the way this town works. You know, I presented the proposal to the zoning administrator because I wanted to go about this the right way and involve the town from the get-go. The process is laid out in the town website. It says if you want to expand your house, renovate your house, you need to talk to the administrator, which I did. I knew it was going to have to go in front of Harb, so I wanted to be completely transparent about the whole thing. That's why we're here. You know, if I thought that I could just get a building permit without this, then I would have. I believe that I have that right, but I knew that it was going to have to go through town anyway, so that's why I presented it to the administrator. I provided a copy of the proposed plan and the elevations of the addition. And it's, as you can see, it's a modest addition to a very small house, just to make it a more usable residence for my family, and it's all within the approved setbacks.
Well, it seems like one of the big hiccups here is that we're going from what was originally a building plan to do a one-bedroom structure. And the fact now that it is like more than that, even though it lies within the footprint that was in the original site plan, right?
But that's what the purpose of setbacks are for, so that you can build up to those setbacks.
Yeah, I'm not arguing that. I'm just saying that it seems like one of the issues that came up was that that it was no longer, I mean, you're building beyond what the building permit originally allowed.
Well, that's why I'm asking for an addition.
Right. But
I mean, I can't.
I guess I'm not asking.
I mean, when you go for a building permit, you don't say, well, I'm going to add on, in 10 years, I'm going to add on to this house, and I'm going to put 2 bedrooms on it. You apply for what you're building, which I did.
Right. But you also applied, it sounds like, for a footprint to eventually be able to add on.
That's what I'm doing now.
No, the clarification is when we started building, Chris realized that within that setback, that front north setback, he could add 2 feet to that. And the building administrator or somebody,
David Self.
thank you, brought that to our attention. So Chris went and applied for that additional 2 feet, which was granted. There was no real grand site plan. It was a 2-foot
Right.
into, which still stayed within that,
And that's why he didn't ask me to resubmit the site plan, because it fit within the setbacks.
and the house itself, the design did not change at all. It was exactly the way Harb
Harb.
approved it. Well,
Mhm.
It was exactly the way they approved it. It just was 2 feet wider, I guess if you want to call it wider.
I think he wanted a bigger closet or something, didn't you? I'm not blaming it on you.
Wanted a washer and dryer.
Oh, washer and dryer, washer and dryer.
So,
The site plan, which we're working with here, which you tried to fit your footprint of your house into, was approved apparently in 2022 with the advice of a former zoning administrator using the zoning ordinance as he interpreted it. Okay, so you went with that based upon what he said and came up with a proposed building envelope. And so we're here now because you're expanding the use of the house, which, again, I would think maybe a non-conforming use just by virtue of what I read. But you're also asking for a shed, which is beyond that building envelope. Is that correct?
Yes, sir.
Okay. So, okay, I just wanted to make that clear because I think, okay.
And Roy's site plan he approved, our
Yeah.
setback lines are only the 10 feet, and he approved that, and now I'm looking at it more properly. And that's there.
Yeah.
I don't know that we can go, we can't renege on what he's done.
Yeah, well, I would just say, as I said at the last meeting, that we've been through 3 zoning administrators on this, and a couple of them, I think, weren't fully engaged, maybe not engaged, but
Well
as,
versed.
as well-versed in zoning and zoning practice, and
Exactly.
made interpretations. And-
Right.
And I'll tell you what, our ordinance, as I said at the last meeting also, is outdated.
Yes.
Needs to be revised.
Yep.
And is creating a lot of confusion. And so, you know, I agree with you, Martha, that the zoning administrator, Roy Kime, relied upon the zoning ordinance. Mr. Costin is interpreting the zoning ordinance as a professional zoning administrator, which he has been in counties and towns, and is well-versed in this area. But we have a former act by a former zoning administrator who has led an applicant to believe that they could do something here. Frankly, if I'd
Absolutely.
been on the Board of Zoning Appeals in 1992 when this was proposed, I wouldn't approve the lot,
Right.
okay? It didn't deserve to be approved. It's a subdivision
Exactly.
of property. It
Right.
shouldn't be there.
Right.
But it got there, so we're dealing with that as well. There's been a lot of action in this town in the past, which has been taken and made because, oh gee, you know, I may want to build, you know, a retirement home on this sometime, and I know all you guys, and I'll do what I say, but that was then, and this is now, and what was then doesn't work now. You know, I started in local government in 1980 in the Commonwealth, and we could shake hands and everything worked out. It doesn't work that way anymore. We've got to be more cognizant of the rules, the regulations, and interpret things consistently. And we haven't had consistent interpretations over the past few zoning administrators. So I can't fault Mr. Costin. I can't fault Mr. Kime. They were working with the level of expertise that they had.
Absolutely.
But we got a real thorny question on our hands to resolve, because we got a lot shouldn't have been approved in the first place with a building envelope which didn't really address frontage the way it should have in the zoning ordinance. And now we have a zoning administrator who's interpreting the frontage as it should be in the zoning ordinance. So that's why we have the conflict. But past actions by the town have led us to where we are. And
Absolutely.
it's difficult to penalize somebody when they buy a lot, and the town has taken action, and
And here we are.
here we are. Yeah, thank you.
Can I respond to a couple of things?
Sure.
Thank you.
That's all right.
Thank you. Thank you very much.
Sure.
One thing, we have had someone sign.
No.
We have had someone sign, so when you're ready for
Oh,
comment.
okay.
All right. I quickly read through those minutes from 1990, and if you have done the same, you'll recall that there was discussion about the road and how the additional traffic on the driveway was going to be an issue. It was always intended for that driveway to be the point of entrance onto the property. I don't want to go off on a tangent here, but a lot of people describe, oh, it's waterfront property, that's my front yard. No, it's not, because it's based on the road. Because every piece of property has a way to get to it. It's the road. The front yard being tied to the street is like the sun comes up in the east. I mean, it is just that basic in zoning. So that completely changes what has historically been somebody's interpretation. As Mr. Anderson, the first variance request was a bad decision.
Right. Well, I think we all agree on that.
The issuance of the permit with it 10 feet off the road without a variance, bad decision. But If you go back to my memo, I clearly state, what's there is there, it's vested. We're not going to go back in time. We can't make the world spin backwards like Superman, okay? Well, that's what we got, okay? The question is whether or not that block, and that block could have been easily drawn to fill in all of that proposed building setback area, but it was drawn as a block. What you have before you this evening is a variance request for something that's not exactly a block. It might fit in there, but it's a different footprint. And that's what I would hang my hat on to say, that's not vesting. But now, and as to certainly, I think Mr. Anzavino was tracking on this, certainly the shed is not there. That's not on the original plan. There is some type of construction, a lean-to, whatever. I'm not sure if that's technically a structure or not. That would be a call for the building official, but if it is a structure, it's not permitted. It hasn't been permitted. That would basically be what I wanted to respond to, was the get a chance to point out that you have a speaker and whether that road determination is done, okay? That's the way it's going to be. I mean, it's always been like that. It was just misread, it was misapplied because of that original variance that looked at it this way rather than that way. Okay? Thank you.
Can I respond? May I
Sure,
respond?
sure.
Regarding the shed, I'm asking for well, what's there now is a temporary shed. So there's no foundation or anything. And what I'm proposing is a temporary shed it's on wooden skids. And from what I can read in the zoning ordinance, and I've read it many, many times, there is no stipulation that says that it can't be within the front setback. It just says it needs to be 8 feet away, which I am in my proposed drawing.
Well, okay. That's not, I think the issue, though, is that it's, and I think I'm right on this, but I think it's 5 feet of difference there with what you're asking for. You're asking for 5 feet of variance, if you will.
Well, those are Mr. Costin's words,
No,
because.
those are mine, because I'm just looking at it and saying, if you need to have 40 feet and you've got 35 with that 28 foot there,
Yes, sir.
then,
But I'm saying there's nothing in the zoning ordinance that says that a shed cannot be within the front setback.
I see.
So it could be,
Because
in
it's
the
a
way
shed.
the way I read it right, correct, that it could be 8 feet away from the
Gotcha.
property line
Okay,
in all directions.
yeah. Okay,
I mean, I assume that it was written so that you didn't put a shed out on the street, but it doesn't say that in our zoning ordinance that a shed cannot be in the front setback.
okay. Do we have any more questions for Chris or Ted?
Could I speak again?
Yes.
I hate to do this to you.
No?
I'll read you. It's all about interpretation, and I'm the one that gets paid the big bucks to do the interpretation. Accessory buildings in the R1. No accessory structure may be within 8 feet of any party lot line. Street is not a party lot line. There's the language.
Yeah, I had looked at that.
But that's off the street. I'm measuring it from the street. The definition of street, which I included in my report with the attachments, says that the street is a public or private access point. That does not make it a party lot line. It's the street. Again,
I'm completely confused.
So
It says 8 feet, here are the party
Yes, ma'am.
lines.
8 feet,
Yeah,
8 feet, that's a party lot line.
right,
That's a party
that's,
lot.
exactly,
That's the front yard.
right,
The 8 feet only applies to the party lot.
right,
lines.
and this is showing that that.
It does, yes. What's at issue, what Mr. Reddick is saying, that the front yard, the 35 feet,
Yeah.
could be as low as 8. And I'm saying
I
that is
see what you're
not
saying.
the
Okay,
case.
sorry, I misheard the things, yeah,
Now,
gotcha.
also, I have, if you'll bear with me, I just got these. Ms. Lowe asked about the history on the building permit. I did not mean to get into this level of detail, but I asked Mr. Self some follow-up questions, and he sent me an email with a number of attachments, including the original site plan, original footprint. Here's the printout for the building permit. And here is where, that's the notice.
Right,
Here's where the application for the county. Again, I just got handed these. And I didn't think we'd have to go into this detail. Here's the amended building permit calculations. And again, more drawings. So I'll give you those since you asked the question. Let me see if I have enough. Did you have enough?
I don't.
Only get
I
two?
think that was one of the reasons.
Okay,
I could do
so,
more.
there you go. If, Ms. Lowe, after you're finished, if you'd pass it down, because we
I
just,
will
we
be
didn't get
happy
enough,
to, sir.
enough copies.
Share.
Thank you.
Okay, so that's just the original.
It's about the shed. But this doesn't,
Does that help?
that's all for what's there now. That's the way I read it. For what's
Yes,
correct.
right,
Yeah,
exactly.
okay, so, but it's not our job to tell people.
That's kind of what I'm wondering about. Yeah. But it seems to be, I mean, Ted, if the footprint's there and you go from a one-bedroom structure to a more than one, so you're gonna add on, and you're gonna get a building permit in order to do that, you're saying that the building permit should not be granted because of the, does that go back to the non-conforming issue about adding onto a non-conforming structure?
I don't understand your question.
I don't know if I understand it either.
The dwelling unit is a by right use.
The one that's currently there.
Any dwelling unit in that zoning district's a by right use,
Okay.
okay? As I said in my memo, the vested rights call is very much a legality, but I think there's enough here to say that there's enough of a change from what was presented to what's being asked for as to not have the vested right. So it falls back to, does he meet the variance criteria? Does the request meet the variance criteria?
Or does it meet the variance criteria he was given in 2022?
You're making the decision today.
I know.
You're making the decision today.
Oh, boy. Okay.
Get a call for public comment?
Yeah, I suppose we might as well. One other question about the shed. I guess since we're kind of doing all this at the same time. If the shed were smaller, would that take care of the situation?
That was a suggestion that was given to him.
Okay. I guess I got my answer.
I would like to do a 28-foot-long shed. It's what I need.
Okay.
That's all I can say. And in my interpretation, that it fits, and it's very much in keeping with the rest of the neighborhood. Cannot be seen from the street. You have to go back to the property to even see anything. So I just, that's all I can do.
Just to say, I know it's probably grandfathered in, but our neighbor right next door.
Mrs. Riddick, if you're gonna speak, can you please come to the
Yeah,
microphone?
I'm sorry. It's
Doesn't
all
record.
recorded, so it all has to be.
Sorry. I just wanted to point out that with our neighbor next door to us, who is kind of in the same boat we are, if everybody looked at the zoning differently now, because they share the driveway easement, but there is also a permanent garage, what would be considered in the same setback that we are on the property line.
Yeah.
So there's no,
I mean, we're surrounded by non-conforming, and I know we don't want to.
There's nothing we can do.
Correct,
about
I
that.
understand. But I'm just saying that it is very much in keeping in the neighborhood, and actually more in keeping with the zoning ordinance than anything, being 8 foot off. And it fits in the same footprint that I have my temporary shed there.
Okay.
Is a shed on skids considered temporary or
Yes,
fixed?
it's
temporary.
it's not a permanent foundation. So it could technically be moved, and it would come in, on
Yeah.
a trailer. It's very similar. I was looking this weekend at the shed that's at the Small Town Burger. And that's right up against the property line. And I know that's separate, different zoning, but it's very similar.
Yeah. Okay, thank you.
Yeah. I'd like to add to this conversation if I can, but
Well, I
I'm the
don't,
guy that actually. put
I'm
my
I'm
hand-
happy for you to do so, if you could come up to the microphone.
Okay, 3 minutes.
3 minutes?
Could you identify
I
yourself,
can do,
please?
yes. I'm Dr. Stephen Connolly. I own the property at 220 Watling Street. I have 110 feet of property line with Chris and Crystal. I've looked at this, I've walked the land with Chris, and I will tell you that I have no problem with what he's proposing building. And nobody is more impacted by the amount of property line that we have than me. That's all I have to say.
Okay, and that's what you had signed up to say?
Yes,
Okay, very good. Thank you. Okay. Do we have any other concerns or questions that we need to have? Okay.
What is that ordinance about sheds again?
Oh, I'm sorry, I've got it here.
Oh.
I took it.
It was,
Accessory
Might-
buildings.
Okay, and
It-
this
it's
might,
in the
this might be a
original.
stupid question, but if it's temporary, does this ordinance even apply?
I'd have to consult with the building official, because size, there are size factors that once it hits a certain size, whether it is attached to the ground or not. But in Middlesex, because it's a hurricane community, they want it attached to the ground.
I see.
Now, there might be
Interesting.
things that aren't attached to the ground, but if you ask the building official, they're going to tell you to tie it down
Yeah.
and attach it. That's not in the zoning ordinance. I said the building official.
Right.
But you don't have to get a building permit for a shed.
right.
Oh, the
Depending on the
things.
size you do.
Yeah. John, you
Oh.
got a, oh, sorry, go ahead.
No, I was just going to say the comment that, I was just making a comment about his comment. Go ahead, please.
No, I don't have anything.
Okay. Okay, anything further, Ted?
I don't have anything else. No, sir.
Okay.
Ted, you might want to focus them on the three initial findings that are in the statute.
Yeah, I'm sorry. Again, in my opening remark, there's a set of three variance finding,
Yes.
variance 1, variance 2, variance 3, and you can go through those. Those have been marked up by the county attorney. I'm sorry, the town attorney.
I'm
But
sorry.
there's also a blank one that was given out at the last meeting that, you know, the board is free to fill out on its own.
Or they could edit, add, delete to what they have in front of them, correct?
Correct.
Okay.
May I say one more thing?
Sure.
There is a site plan that I gave you that shows my, yes, that,
This one.
that is what I would very much like for you to consider approving.
And
Well-
was that part of the application?
Is that what
No, I
we're
think
doing?
it was submitted tonight, is that correct?
Yes.
Yeah, then that has to be a separate consideration.
Okay.
It wasn't advertised, it wasn't applied for, it can't be done.
It fits within the original variance.
It fits within the original variance, so that's all I can say.
Yeah, I would think, but, I mean, that's why we have the town attorney, so I guess we've got to do that.
So to help, maybe help clarify, go back to my memo, the last item is what was advertised. And what's before you.
Okay. Well, I guess if there aren't any other questions or comments, then the public hearing regarding zoning amendment 2024-VAR-01 is now closed. So, do I have a motion to recommend or not recommend? I guess we need to go through these one at a time.
Yes, sir.
So, let's see, with the first one, the first request, variance requested to add existing residence with the existing 10-foot setback. So that would be for the main building.
Would that
All right,
not
what is it?
Would that not be an expansion of the existing residence? Because there's a house, there's a renovated home there. That's what we're looking for, is an expansion of that existing home, right?
Yes. It's to add to an existing residence.
Okay. Ed, I'm sorry. Missed-
I may not have.
No, I
read
missed that.
correctly.
No, it's me.
Okay.
I really feel like people are muddying up this whole thing. We haven't even talked about 12 feet or anything. We're talking about the 10.
Well, if it's, my understanding was that the, well, let me see.
Okay.
I got so much
I know.
stuff here that, oh, here it is. So it's actually 12 feet off of the west side, right?
If I may point out to the screen, those are the three that are broken down.
Oh, okay.
So
Requested to add-
they're just numbered 1, 2, 3.
Okay,
Oh, okay.
so this is the 10 feet that,
So that's your Riddick variance, the document that says Riddick variance request number 1, that's number 1. That's the 10 feet on the front. Riddick variance request number 2 is your 12 feet on the rear.
Oh,
And then number 3 is the shed.
oh. So the 12 feet on, in the rear is from, okay, so that would be like the backyard.
Yes.
Okay.
The side opposite the private drive.
Okay. So the first one is the existing 10-foot front yard setback,
Right. Which was our,
adding to the residence with an existing 10-foot front yard setback. So do I have a motion?
I move that variance be confirmed, is the language, because that was already given by Roy Kahn, is my understanding.
I'm sorry to interrupt, but there have to be fact findings made.
And I think she was in the process of putting that into the record.
Yeah.
Okay, all right, thank you. I didn't know that. Thank you.
I don't know.
Proceed, I'm sorry.
I think, Martha, what you were getting to was you're voting to approve variance 1
Yes.
with an existing 10-foot front yard setback where 40 feet is required by ordinance because of prior actions by the town to create a lot, which is a non-conforming lot, and by prior interpretations of the zoning administrator, or zoning administrators, former zoning administrators, who,
That's not the statutory criteria.
then you do it.
The BZA only has the authority to say yes or no and provide the fact based on what's been presented, based on what is in the statute. You can't make up your own findings.
So what took place in the past doesn't matter, and what the town did maybe incorrectly in the past doesn't matter as part of the motion.
Well,
That led us to this point in
do you
time.
have the document in front of you that has the statutory questions?
Yes, they do.
Okay, so, yep, does the strict application of the terms of the ordinance unreasonably affect the utilization of the property?
And we're saying,
Yes or no?
I'm saying yes.
yes, it does.
Okay, and then based on what facts?
The facts that they were stating was the prior allowance of interpretation. Well,
No. The strict application of the terms of the ordinance, in other words, the existing setback requirement. The question is, does the current setback requirement unreasonably affect the utilization of the property?
Yes.
I'm trying to help the board out here, Andrea. I see your point. But as Mr. Anzavino was saying, they're presented with a set of facts today that are resulting from prior bad decisions. Okay?
That doesn't matter.
Well, then why did we even discuss that?
Right.
Then
I mean, I understand what they're saying, but the only question is, does a 40-foot setback requirement unreasonably affect the utilization of the property? That's the beginning and the end. The law is replete with cases that say you cannot go outside the statute. They don't have that authority.
Apparently.
So, if
Matter
the
even.
board
Right.
finds that a 40-foot setback unreasonably restrict the utilization of the property, then they need to state the facts, like why.
because of the prior,
Because it's already
the
there.
prior variance they
It has to be
create.
based on the ordinance, period.
Those decisions were based on the ordinance and interpretation of the ordinance.
Well, I mean,
Yeah,
I can only say that the question is, does a 40-foot setback unreasonably affect the utilization of the property today?
And it could be argued that yes, it does because of the prior errors in allowing the lot to be created and the prior errors in misinterpreting front yard, rear yard, side yard,
errors and approvals.
errors in approvals.
Okay, but the errors and approvals, how does that relate to the ordinance?
Because somebody was interpreting the ordinance
Okay,
incorrectly,
This
but
is about the interpretation now.
Okay, so we don't really have a decision.
I'm trying to help you out here, folks.
And
I
that's
really,
fine.
Yeah.
Yeah, she's already
I'm
made
not
it.
trying to be argumentative, I'm just saying, you know, if this goes to the circuit court, and I would say it's likely to, we want to at least do this the right way so that then the court could rule on it.
can I ask the board a question? And particularly Ms. Lowe. Ms. Lowe, what you're trying to get to was cleaning up the 10-foot setback? Is that what you were trying to get to, is like,
Yes, because, are you gonna make him tear his house down?
no.
Exactly.
That's in my memo.
Yeah,
So,
exactly.
it
I
would-
think we have to say yes.
So
to
let
that.
me rely on your expertise. Doesn't this put a cloud on the title without a variance on that front yard?
The variance has been given.
No, that variance has not been given. The permit has been issued, but,
And the structure is already there.
Right.
And the 10-foot and everything was approved.
so, but what I'm trying to get to is you're trying to clean up for the existing building. Is that what you're trying to do? Or
Yes.
you're trying to clean up for the existing plus the addition?
I didn't say that.
That's kind of what I'm trying to get to.
Thank you.
Okay, all right. So I think what Ms. Lowe
Okay,
was
but-
trying to get to, let me finish please, was to try to clean up, the error that has been made by granting the variance. Like,
Yeah, I understand that,
Okay.
but that's not their role. They are being asked to grant a 10-foot yard setback where the ordinance requires 40 feet. And the first question is, does the application of the 40-foot setback unreasonably affect the utilization of the property? In other words, can you still use the property with a 40-foot setback?
No.
and
Well, no,
the
obviously.
answer would be no.
Okay, and so what are the facts that support that?
There is a house there already, a dwelling there.
But that doesn't support that. What that supports is the other answer, because the 40-foot, the 25-foot eats up the depth of the lot.
We're not addressing the 25.
You will, but you will be.
Exactly. We're doing one at a time.
Thing, Ted.
Okay. Folks, all I can tell you, you've heard the advice of the attorney, and I think I know what you want to do, but
So, in other words, you know what we want to do, but we can't do it.
that's what I'm hearing.
Okay.
Me too.
At least for
So I don't know
at
what
least for
we're-
the
So
existing.
why'd we even hear?
And I'm not trying to tell the BZA how to decide, I'm just trying to focus the issues and then
I don't know what to do.
make sure that the BZA articulates the corresponding facts.
Okay, so in other words, we can't get to saying, okay, with this part of it, just because we think that there was a prior mistake made and a house built there, and it was approved, and the building permit and everything is there, we can't accept that.
And he has.
I think the question's to you, Andrea.
Yeah, no, I know.
doesn't
the
make any-
way that the law is framed is simply whether the application of the ordinance, you require the 40 feet,
5,000
would
times.
unreasonably affect the utilization of the property. And my understanding is the property is currently being used, right?
Yes.
So how can you argue that the application of the ordinance unreasonably restrict the utilization of the property?
If
I
we were to
understand.
take away the existing structure, this was a greenfield site, nothing's on it.
Okay, but that's not, we have to deal with what we're looking at. He's got a non-conforming structure and a zoning violation that you have said you're not inclined to do anything about.
Correct.
The request is to expand the structure and to expand into the front yard setback further.
No, it's
No.
not
No.
the front line.
It's the 10-foot that's already there.
I don't know either.
I'm going to say this. And I'd like to be able to finish my thought.
Okay.
If this was a greenfield site asking to put a structure on it, the 40-foot together with the rear yard makes it it's an unreasonable because of the problem with the lot being created. But there are a number of lots in the town that were created long before zoning where the 40-foot would be a problem. So, or the rear, or the addition of the rear yard in the front yard would be a problem. What I
Right,
think they're
and so-
trying to get to is to clean up the existing, it's been done, clean it up, take the shadow off of the property by granting the variance for the existing building.
10 feet.
In light of what the ordinance says, in light of how the ordinance was applied, that's, I think, what they're trying to get to on the front yard.
I understand, and they're trying to cure a violation with a variance, and usually a variance is requested prior to engaging in the construction.
It wasn't a violation. It was approved by the town.
For the front line has already been approved
And
by the town.
by the county too.
Ted, why don't they go on to question number 2, and I'm gonna do some legal research.
You mean request number 2?
You go to variance number 2. That's the rear yard.
No, not variance number 2, the second element
Oh,
on
the
variance
the
number
second
1.
element of number 1. Okay.
Okay, variance would alleviate the hardship due to physical conditions related to the property or improvements that were there before the ordinance approved.
The hardship is created because he'd have to tear down his house.
No,
That's a physical condition.
No, I think
Existing structure.
physical condition means more like the topography.
Yeah, and he
Say
couldn't
depth of
build
lot?
because the lot was too steep
all
or.
of the lots in that area are the same.
No, they're
As far as,
not.
as far as topography,
No, they're not.
along the creek.
Okay,
Wasting time.
We didn't create this hardship. We didn't create this hardship. We went through the town, we got approved, north, south. Mr. Costin has created the hardship by spinning our property.
Mr.
And-
Chairman, if public comment is closed, I would recommend you take control of the meeting.
Okay, I'm sorry.
Exactly.
All right, well, so I don't know where to go.
Yeah, there's no way to get to yes here.
Yeah, we're,
according to the
we're-
town attorney.
so there was the decision had already been made.
Yeah.
Well,
So I guess so that's the same thing with variance one, variance request two is gonna be the same issue. So variance issue, request number three is the one that, is the only one that we have any right to make a decision on.
Okay, what was the answer on question number 2 for variance 1?
No.
Well, I think it has to be no.
You think it has to be no? Is that what you said?
that's what the,
That's-
Mr., the chair, the acting chair said.
Okay, and then what about question number 3?
That's definitely no.
That doesn't apply, right, because there's no disability?
That's correct.
Okay. So, if, with variance number 1, hypothetically, let's say that let's say criteria number 1 has been met, okay? Until I finished researching it. Then you go to the next page. Is the hardship self-imposed?
No.
No.
Well, they bought the property in this condition, right?
No, ma'am.
I don't really think so. I mean, they were approved, it was approved for them to do the building.
They didn't get, when did they purchase the property?
2019.
2019, Andrea.
Okay, so they purchased it with the prior interpretations and restrictions and nonconformities.
That's
So
what-
how can you say that the hardship was
We're not saying it was
not
self-imposed.
self-imposed?
The prior owners self-imposed it.
The question is whether the hardship is self-imposed by the Riddicks.
And the answer is no.
If you're saying that they should have known, I guess, then, is that the criteria? Knew or should have known?
Well, if you say that it wasn't self-imposed, what would be the facts that support that?
What? We
better
can't.
not.
I mean, 'cause
Okay, well, if this is a yes, then it's another stop.
right. But I would also assert that under question, I mean, I think you ought to answer these questions and.
We've
like,
tried
think
to. You
about
won't
what
let
the
us.
facts are and answer it based on those facts.
Well, I think they've been trying to work through that, and can't really get complete thoughts down. So,
Okay, you want me to stop talking?
well, I think to let somebody get their complete thought down to say, okay, how do we tweak this so it's better?
Okay.
and what they're trying to get to.
Well,
I don't know how we're ever going to do that.
I don't either.
We'll
So
never get
if you want to go back to number one, and and again, from my understanding, you're trying to get to a point where you can say we can live with a variance on number one because the existing structure is already there, it was permitted, and we can live with that part.
okay, so is somebody on the BZA filling out the first one?
I don't know, I can't see from where I'm sitting.
Filling it out, what are we talking about?
Fill it out, the findings,
Oh, I got to fill all this out?
well, just
Got to put some ideas.
some
out
jot
there.
down some notes, bullet points.
There should be an easier way. Okay, could you repeat what you said, Ted?
What I said was, I think what you're trying to get to is a way to grant the first variance so it covers the existing structure and the 10-foot encroachment on the front yard setback.
But the factual question is how does the strict application of the setback requirement unreasonably affect the utilization of the property, given that there is a current use of the property?
Okay, again, we're in a corner, we can't move here. I mean, I don't care how you word it. You got to answer it yes first.
Okay, I got yes. And so I don't want to put words in your mouth, I'm just asking how would you articulate the factual basis?
Well, we tried, but
Yeah.
Yeah, it's not working.
yeah,
Again, the factual basis is the facts that they have before them this evening is a lot that should have now been created, a permit that should have never been issued for the movement of the shed and placement of the shed where it is. And those are the facts.
And I'm not being sarcastic. What does that have to do with the ordinance setback requirement?
the ordinance was improperly interpreted, leading this to occur.
So there's your tie to the ordinance.
Okay, the facts are that a lot should not have been created and a site plan not approved. Is there more?
I wouldn't do it in the negative. I would say that the lot was created and the variance was already approved prior to
Well, not the variance, but the site plan.
the site plan. Thank you, Ted. Was already approved.
Okay. And then, what is the answer to question number 2?
I don't understand the question myself.
I'm not sure I do either, but
Well, the physical conditions of the property are its lack of depth based on the bad platting and bad interpretation on the site plan, the yardage. So I think you can use the same 2 points.
What does that have, okay, so. Say that again?
I think you can use the same 2 points. The hardship is due to the lot's lack of depth
it's just like a test. You have to turn.
from the street back to the Connolly property line. And so there's your hardship. Again, it falls back to the lot shouldn't have been laid out like it was, and the site plan shouldn't have been approved like it was. It is the exact same 2 points that you used to get through question number 1.
Okay,
And-
I wrote down lack
It
of
appears we don't have to answer
Okay.
all of these questions because it's an
And number
or.
3, we know is that.
Exactly.
Okay,
Right.
so
So why do we go
is the
through all of this
hardship
crap?
Good,
self-imposed?
good question.
In other words, what that means under case law is, were these limitations there at the time that the property was acquired?
Yes.
You could say yes, but for the change of the interpretation to the correct interpretation regarding lot designations.
Were the limitations there when the property was acquired?
Yes.
I mean, has the shape of the lot changed? Has the physical physical characteristics changed? Have structures changed?
Well, when it was acquired, there was no structure on it. What changed was the placement of the structure at the wrong spot.
Did they? So help me understand whether it's yes or no and what the facts are. And I need to hear from the BZA, Ted.
I was trying to help them out. Okay.
I know.
I don't have the background to do this. I'm sorry. Do you want to take a shot at it, John?
Well, the improvements weren't there before the ordinance was approved. Again, the hardship is again created due to prior town interpretations of the zoning ordinance, the Board of Zoning Appeals' original creation of the lot, which becomes a lot which
Right.
creation of the lot and the approval of the former zoning administrators to allow a structure to be located on the property. That's the best I can do. You know, if you're talking about topography, you can't build into the RPA, and that's not an issue. The lot doesn't have any limitations on slope, other than as you get down towards the water, as I assume. So, you know, the only physical limitations are the creation of the lot, the lack of road frontage, other than a deeded right-of-way, which is interpreted to be you know, something which is acceptable to the town. So, you know, the fact that this lot was built on, created, and it shouldn't have been, that's the best we can come up with.
And that's actually the answer to the first question. The
Yeah.
second question is
Yeah.
irrelevant if the first question is answered yes,
Yeah.
right? Because it's an or.
Right. You know, if we've answered the first question, we don't have to answer all three, do we? It says if one of the previous three criteria have been met, then proceed.
Yeah, I just wasn't clear on the, right, we passed page 1, and so now on page 2, these questions have to be answered.
And then, please note at the bottom, must find the answer no to all 5 of the above questions. If all 5 of these conditions are no, then the variance must be granted. So you're saying it's no on the first one because it's the history of the lot, the permissions.
Okay.
Will the granting the variance be a substantial detriment to adjacent or nearby properties?
No,
No.
Sounds like that's a
No.
no.
Okay,
Was, okay.
You had testimony tonight to that effect.
Exactly.
okay, so on the acquired in good faith, and I'm looking at a case, it talks about was the property for which the variance is being requested acquired in good faith and any hardship was not created by the applicant for the variance. I don't know if that helped you.
Well, I don't think it was created, I mean, the hardship is in the property itself. It wasn't created by
The applicant.
the applicant.
you know, the hardship was created when the lot was created,
Exactly.
Yeah.
and previous interpretations were made.
Right, but what a court is gonna say is that those interpretations and the lot was created at the time it was purchased.
Correct.
So by definition, that means the hardship was self-imposed.
By her interpretation.
I would say that that has been the general finding of the courts. But, I mean, again, you can put whatever you want.
Okay. So I guess we go on down the list.
Yeah.
To really do this?
So, I'm sorry, you all got through, will the granting the variance be substantial detriment? You all said no. On the one based on the testimony you heard tonight, is the condition of the property of general recurring nature? Is that the one you're at now?
Yes,
Yeah.
yes,
Okay.
that would be a no.
No. On the first page, number 1 and number 2 are yes, and number 3 is a no. Now we're on, is the hardship self-imposed?
We've gone
We've
by that.
gone on
They've
that.
gone by that.
Okay, so the answer is
No.
No.
no. Okay, I'm sorry, all right.
Okay. Then on the next one is no because of the testimony they heard tonight. The third one is no. Is the condition of the property of a general recurring nature? I can only hope that there aren't any more lots like this out there.
Exactly.
Okay, but I need you to stop. So the facts on number 1 that support the self-imposed are what?
Would one of you all like to state it? I think I've tried to summarize, but apparently,
I think what we had said was that the hardship was created by the creation of the lot itself, not created by the applicant.
Okay, but the applicant purchased the lot.
And that's why I said, is that by definition creating the hardship? Does that mean self-imposed because of the purchase of the lot?
And my answer based on case law that I've read is that the answer would be yes. In other words, let me give you an example.
No.
So, I buy a piece of property and I'm planning to build a house on it. And I don't get around to doing it, and then there are environmental regulations that are passed that make it so that I could only build a small house, and I really want to build a large house. In that case, I think there might be an argument that it's not self were not in place at the time. And, you know, now I have limited ability to develop the lot. Another example from a real case is the Gate and Triangle case, where it used to be that for the whatever business district it was, you had to have a minimum 1 acre lot size. And then Henrico County made it a requirement. I'm sorry, it used to be that you had to have at least a third of an acre. And then Henrico came along and passed an ordinance that said you have to have a minimum of 1 acre. And so in that instance, it's not self-imposed because it's something that happened after the guy bought the property.
All right, so we could say that they bought the property and built on it under good faith, and the imposition of the correct interpretation changed things for them. Can we go with that?
Yes.
Yeah. They built on,
Say that one more time, Ted, so I can write it down.
That the imposition of the correct interpretation regarding yard designations was the hardship, because they had relied on everything, they got earlier building permits and everything else.
Was any of that done before they bought the lot?
I think you could go all the way back to the 1990s when they talked about,
No,
when-
Did a governmental entity pass an ordinance after they purchased the lot that has now affected what they can do with it?
no ordinance was passed. It's the application of the correct interpretation regarding the lot's yard designations, which is in the ordinance, and was in the ordinance, and has been in the ordinance. But getting to Mr. Anzavino's point about the prior errors, they relied on the prior errors, so the change is the hardship for them.
Okay,
So we threw that one.
I think so.
The second one, you heard testimony from the adjacent landowner. But keep in mind, you had testimony last month of a,
I mean, that's a factual finding that the BZA has to make.
I'm trying to help them, get through this.
Okay.
Okay.
Okay, the facts to support this is that we heard testimony tonight from the neighborhood that it will have no impact on them. Prior public hearing, we heard one comment about the color of the house not being in conformance with HARB requirements, which will be corrected.
Is the condition of the property of a general or recurring nature?
No.
No.
I would encourage you to look at the map of all the lots in that area.
Given the nature of the area and what is, it's a built-out area, there's minimal potential for development within the town of Urbana, within that area. And so it's not a recurring nature.
Okay, so, but what if the town passed an ordinance that said for that area, you only have to have a 10-foot setback?
Okay, what if? That's not the issue we're talking about.
Of a general or reoccurring nature.
Oh, God.
But again, looking at the total history of this lot, which many people have said, it should have never been created. It has a history of misinterpretations and application. That's a unique history. So would the granting of the variance result in the use that's not otherwise permitted? I stated earlier that the use is a single-family residence. That's a use by right.
All right, so I have the feeling that what I'm doing is being an obstacle, which is not my goal. My goal is to articulate facts, and Ted, in trying to help out, keeps saying the same thing over and over.
Because that's the best, really the genesis of this is the condition of the lot.
Well, then just, I mean, you know, I think that the BZA can either just do what it wants or, go through these things, but I'm not trying to give anybody a hard time.
Well, the applicants have left the room, but I think we have to keep going.
Okay, so does somebody want to make a motion or provide direction on what you want to do on variance number 1?
Thought we already did that.
Yeah, I think we did that. Do we need to restate that?
It probably would be helpful to restate it.
Give it a whirl, John.
If I can remember what I said.
I know, it's really difficult.
Yeah, the water's been muddied on this.
Yeah. It's just about the current 10-foot setback line.
I move that variance request number 1, requesting the addition of an existing residence with an existing 10-foot front yard setback where 40-foot is required by ordinance, be approved by the Board of Zoning Appeals of the town of Urbana, because of prior interpretations of the zoning ordinance by the town, the Board of Zoning Appeals of the town, creating the lot, and the approval of the site plan by the town, which has given the applicant belief that the property could be built upon.
Second.
Okay, all in favor?
Aye.
Okay, so we go on to
Number 2.
number 2. And this one, variance requested to add to an existing residence a 12-foot rear yard setback where 25 feet is required.
Essentially the same.
It's essentially the same. Does that suffice, that it's the same description?
It'll have to be.
Still need a motion.
Martha, you take this.
Oh, heck. Variance requested to add to, variance requested to add to an existing residence at 12-foot rear yard setback where 25 feet is required, shall be allowed. Is that the right terminology? Due to prior decisions made by Board of Zoning Appeals in 1990s and the zoning administrator in 2022.
Second.
Okay, all in favor?
Aye.
Okay, and then for variance request number 3, requested to construct a proposed shed with a 35-foot front yard setback where 40 feet is required. Do I have a motion?
I have questions still on this.
Okay, well, how do we do that?
I think you have to make a motion and then I can question something, right?
Okay. Well, I'll make the motion. I move that variance request number 3 to construct, and this is to construct, not place, it's to construct a proposed shed with a 35-foot front yard setback where 40 foot is required, be denied.
Yes, and y'all had talked about doing smaller anyway, right?
Well, this,
No.
but this is construct is the actual wording here.
Construct, yes.
That's terminology.
I know, I'm not sure what difference that makes.
I think, construct is, to me, is
Affixed.
being fixed in place.
What's the motion?
Variance requested to construct a proposed shed
Thank you.
within the 35-foot front yard setback where 40 feet is required. The motion is to deny. The motion is to deny. The conversation has been about constructing as opposed to placing.
Oh, okay, thank you.
Oh, on that motion.
Yeah,
Okay,
you're right.
okay. Do I have a second?
Second.
Okay. Now, for discussion.
All right, so if it was to be placed in a temporary, would,
But is that what we're
yeah, that's not even.
allowed to?
To rule on tonight, yeah.
On the site plan, it says temporary. On scale.
Ted, do you
I
have
see
an,
that.
a thought on that?
Again, I've already expressed my thought that, first off, accessory buildings, depending on their size, are subject to a building permit. Okay, that's building code. The other is, how is it tied down? If it's connected to electricity, it's considered constructed, it's considered tied down. It's not on skid. It might still be on skids, but if it's tied into any infrastructure like electricity or plumbing, it's considered a permanent structure. Variances run with the land, so you can't say it's temporary.
Right.
That, well, the owner today wants it, the owner the next owner doesn't want it, and they move it out. It runs with the land. So, I don't know if that helps you or not.
I think it does.
Do we know what the size is that requires a building permit?
I think it's anything over 120. I think that's the number.
120 square.
120 square.
Mhm.
So,
And this is 12 by
Clearly.
28. It's clearly above it.
Well, based on this wording, I think we still have to deny this variance.
based on the construct.
Yes.
Okay, well, so that was the motion, and it
And
was
I
seconded.
seconded.
So, I guess we vote. So, Martha,
Aye.
John,
Aye.
Louis, aye.
Okay.
Okay, well, I think that, that wraps up the meeting, so
We can
meeting is adjourned.
Motion to adjourn?
Thank you.
Do we have a motion?
Oh, motion to adjourn?
Second.
Okay, all in favor?
Aye.
Aye.
Meeting adjourned.
Thank y'all.
Thank you.